What I'm going to do is I'm going to just introduce you to our next speaker, who's going to be Darren Olivier. We are running a little bit behind time, but if anybody has any questions, will you please post them in the chat box, and we're going to try and see if we can answer them later, or if the responsible speaker can answer your question by email. Darren's presentation comes off the back of what Lindiwe has just shared with us about responsible leadership and branding. And Darren's going to share some insights with us, particularly in relation to how you create value through the leadership behind those particular brands. So Darren, over to you.
Thanks very much, Jenny. And hello, everyone. A very powerful talk from Lindiwe. Thank you. I'm just going to dive right in with the presentation from on the updated kind of Theranos story in the United States. If you just bear with me, I'm going to get it onto the slideshow and then take it from there.
Tonight, Elizabeth Holmes facing the test of her life. The 37-year-old arriving in court, her appearance a far cry from the Steve Jobs-inspired black turtleneck she frequently wore as the founder of Theranos, a $9 billion blood testing company the prosecution alleges was based on a lie. This is a case about fraud, about lying and cheating to get money, the prosecutor said. Holmes has been charged with multiple counts of fraud and conspiracy to commit fraud.
We'd like to see a world in which every person gets access to this type of basic testing.
Her promise to revolutionize the way blood is drawn captured popular imagination. Her face splashed across magazines and celebrated Silicon Valley's most successful self-made female CEO.
I've been so impressed by your dogged determination,
convincing some of the world's wealthiest and most powerful that, thanks to her technology, only a pinprick would be required to conduct hundreds of diagnostic blood tests. Today, the prosecution alleging she used the technology for only a fraction of the actual tests, defrauding not only her investors, but also doctors and patients. Theranos was producing dangerously inaccurate results, the prosecutor said, pointing to faulty tests, including those for pregnancy and cancer, that gave patients the wrong information. Problems the prosecution says she was well aware of. The defense painting a very different picture. Ms. Holmes did not go to work every day intending to lie, cheat, and steal, arguing trying your hardest and coming up short is not a crime. So is Elizabeth Holmes a con artist or simply a failed entrepreneur? What a jury decides will determine if she spends up to 20 years in prison.
Right, I should be back on screen, and we'd like to just reflect on that a moment with this current slide that we have on the screen. I think Elizabeth Holmes is incredibly talented. What she's effectively done at the height of her powers, when she raised $1.2 billion in their escapade to make a $9 billion company, is really to get the story 100% right. IP management, her technology supported by patents registered at the USPTO and other registries. Governance, she had the likes of Henry Kissinger on her board, another U.S. ex-Secretary of State, and a litany of other high-profile individuals. She had Richard Murdoch as an investor, Walgreens as an investor, and through that she pitched herself against the late Steve Jobs with the turtlenecks and created leadership and, of course, communicated, and everyone lapped up the story. And she created value. And that's what I would like to say. This is what can be done if done correctly. Of course, there's a dramatic and catastrophic failure as well. And that's because her communication became tested. She lost confidence, and her governance abandoned her, her leadership abandoned her, and her IP didn't work. So it just also shows that a failure with any IP management, governance, leadership, or communication can lead to value destruction. And that's what this talk is all about, creating value and losing it. Bring it into a South African context and to show price sensitivity to IP events. What I call an IP event. An IP event is an IP situation that happens to a company. And we talked about Lindiwe talked about leadership from the top and from the bottom. This represents what happens from leadership from the bottom. The stakeholders who invest in these companies will vote with their share transfers and here we go on the first slide, Vodacom. We've got the release of the McCarthy, please call me settlement that was rejected, and a counter offer for billions of rand in return, and that led to a share price, and that's called an IP event, right? And that's still ongoing, of course. They'll have to deal with that in the upcoming court cases where a decision is to be made. EOH Holdings, a technology company, suffered a very similar type of situation. Here, Microsoft cancelled their contract, a very lucrative IP event, which led to, in the midst, I dare say, of corruption or alleged malfeasance in respect to a public sector contract. And of course, the stakeholders voted with their pens or with the click of the button, and led to a catastrophic drop in value for EOH Holdings. So taking this closer to home, this is not a US-only event. This is very much alive in South Africa. Let's turn to this slide. I mean, it's a favorite slide of mine. Those who've listened to me talk before on IP and value know that I do use this slide, and I've updated it, and you'll see 2020, the slide on the left, intangible assets relative to intangible, decreasing over time. So tangibles decreasing, intangibles increasing. So 90% of all value in a company exists in intangible assets. That's quite astounding. And of course, COVID has accelerated that, hasn't it? So, you know, that's just interesting. But it shows the interplay there. And of course, intangibles are protected by intellectual property, patents, trademarks, copyright, designs, etc., know-how. And then if you shift your eyes just to the right of the screen, and you see Mervyn Key, the famous and authority on corporate governance, giving a launch of the IODS, the Institute of Directors King 4 reports, which bear his name, on governance, and you see a slide representing the exact same slide that I've just done just in 2016. You see that there is a link between IP and corporate governance. And I took that picture sitting in the audience of the Sandton Convention Center. And why it's quite telling for me is that really it does create this link between corporate value, intellectual property, and corporate governance. Let's have a look at that. So governance and leadership, how do we get the two together? Again, we go, I'm going to dare say, the scriptures of the King 4 report. Corporate governance, for the purposes of King 4, is defined as the ethical and effective leadership, something that came through manifestly in Lindiwe's talk earlier today on governance, outcomes, and value creation. Ethical culture, performance, and value creation, effective control and legitimacy, getting back to our circular feature with value creation being at the heart. So governance and leadership go hand in hand. Let's link leadership to disclosure. The governing board or body, which is of an organization, is responsible, effectively its leader, check on management and the executive, for steering the organization and setting its strategic direction. We'll talk about strategy in a second, and approving policy, overseeing and monitoring implementation. But getting your eyes to the bottom and ensuring accountability and organizational performance by means of, amongst others, reporting and disclosure. So reporting and disclosure and leadership go hand in hand. Of course, ethical reporting and disclosure is so much more important. Let's have a look at this one, just connecting communication with value creation. Let's just analyze it one more step further, just break it down. Ethical reporting and disclosure, communication, builds trust. And by the way, this is not just massive organizations, listed organizations. I'm talking about SMEs. I'm talking about our own organization. I'm talking about that small organization that's a startup looking for funding. If you're able to report and disclose, and I'm going to say on your intellectual property, your intangibles, your biggest asset set, you will build trust. If you build trust, you build confidence. Confidence by whom? Your stakeholders. Stakeholders are who? Your investors, your customers, your employees are all stakeholders in your organization. If you can do it effectively, you build confidence and you build value. Human capital, people don't leave your organization. In stakeholder capital, people invest in, and you increase sales. So if you followed me on all of this and it makes sense to you, you would think that full ethical disclosure and reporting on the organization's most valuable asset, its intangibles, its intellectual property, would create value, investment, and an opportunity for growth. It stands to reason, but you'd be wrong. Because in the study of the financial reports of the JSE, of the top 50 companies, intellectual property, the words intellectual property, trademark, patent, copyright, know-how are used only 4 times on average. and 50 companies do not use them at all. And that's excluding, of course, the copyright sign that exists on those financial reports. It's quite damning. So let's understand why and then how we can perhaps address these challenges. I'm going to talk about South Africa, but it is prevalent in Africa. Africa is as diverse as Olivier said, and it's an interesting reflection on how we should promote it. But let's just have a look at South Africa. A lack of education and understanding. People still phone up today and ask to patent their trademark. And I know I'm speaking to the converted here because you're all here and interested, but a vast majority of people and clients do not understand intellectual property. Internally generated IP does not exist on the balance sheet. What this means is that companies of all descriptions are undervalued because they fail to represent the internally IP on their balance sheet, which decreases confidence and trust and decreases the ability for them to raise funds and grow. We're still, as a country, focused on the resource economy, still focused on land as a physical thing, and less so by offices. Exchange control. Exchange control, unfortunately, is outdated. What's happening and what it does is it forces people to externalize their IP, and it creates a huge risk and a barrier to people investing in the country. The IP infrastructure is not what it should be, and I'm apologies if I've got any registry officials there or those from the court. But really, if we compare ourselves even to Africa, and I say even to Africa because South Africa is regarded as the most industrialized country, we are unfortunately creaking backwards. And I'm going to also say that our failure to join the Madrid Protocol is an example of that. Our perceived expense, IP investment is a perceived expense because it takes too long. It's not working, therefore it's an expense, therefore it's a grudge purchase, therefore there's a lack of investment in formal IP. And if you look at the global stats from World Intellectual Property Organization on the investment in IP, you'll see healthy growth for trademarks, healthy growth for patents. And even in Africa, it's the same, off a low base. But South Africa, unfortunately, is pretty much tracking even on trademarks, and I'm unfortunately decreasing and declining on patents. And I'm afraid we're partly to blame as an organization, as a firm, as an industry. It's become a largely esoteric legal, very unique, very specialized. Schools don't teach it, firms don't do enough of what we're doing right now. And as an industry, of course, we appreciate you listening in because that's what it's all about. There should be more of this. As a result, there's an acute IP information gap. Remote working is not going to make it easier. In fact, it's going to add to the challenges. Why? Remote working is going to lead to an increase in consultants, and consultants are notoriously difficult to nurture and protect intellectual property from within an organization. The challenge is going to be quite real as we go forward into remote working industries and remote working environments, so I say. And very few boards, if any, I don't know of one who has an IP expert. They may have access to IP expertise, but they don't really have an IP expert on them, guiding them, leading them, speaking to those CFOs that are taking them forward. Right, enough of the challenges, and I'm sorry if that's depressing, but I think it just helps us understand how we can lead. What can Adams and Adams do? What can you do to assist and turn this into a value creation proposition and create value, create growth, create opportunities, create jobs? So how can we assist you lead on a granular level? Education and coaching. A lot of the teams at Adams and Adams do this at no charge at all. In fact, we enjoy it. Developing your IP value story for stakeholders. We can assist interpret IP into your business strategy and create a value story. People love stories, brands love stories, growth and opportunity arises from stories. We develop IP policies. Karima will be talking about that in the next session. Creating IP asset registers is so very important. If you don't have a register, you can't really touch it, feel it, value it. It's an intangible property, intangible asset. It's the only way you can really grip it and value it. The only way you can speak to those accountants you need to get the funds to grow it. Managing and access to your portfolio, we are working on a number of platforms where you can gain access all in one spot, dashboards on your IP. That's what needs to be done. It needs to be there on your desktop. You can see at the touch of a button where you are. Your strategy, as I referred to earlier, remember, it's not about an IP strategy. It's actually about a business strategy, but your IP strategy must reflect, mimic, and help protect your business strategy. We can help you with input on your financial reporting. Where you don't have internally generated IP on your balance sheet, we can help in the notes articulate what you're trying to do, and therefore create value, create confidence. Gap analysis stands to reason. IP due diligence, health checks and mapping, especially in the context of M&A and your next opportunity. You can gather a lot through IP mapping. And linking IP expenses to value creation. So instead of it being seen as an expense, to be seen as a creation of value. This is so important internally if you're looking for a budget for renewal. Why do I need to renew? Why do I need new filings? Why must I search and file and clear brand? We can help with that narrative to enable you to do that correctly and properly. This is an interesting one, the brand alignment with Adams & Adams. Adams & Adams, we're very fortunate to live in a 100-year-old organization that's got the highest integrity and also, you know, just a brand of quality in the IP field. And what happens is when we partner or when we work with you, we find that there is a brand alignment. So what happens is that the elevation of our clients' brands often happens through the associates with Adams & Adams. I don't want to harp on this. The legacy of this brand started over 100 years ago, but that is a valuable proposition when going to the market, especially when you're seeking funding. And what we've also done uniquely, take people within the organization, and instead of them focusing on silos, patents, trademarks, and filing and litigation, is to bring them together. So we look at the solution to your problem as if you're looking at it as not as separate silos, but as one individual team. And our referral network, through what we've done is we've ventured into organizations like the CFO Center, like the Institute of Directors. And within that network, there are opportunities for referral. And it's not a fee-earning referral network. It's a vested interest in making sure that the innovation succeeds. Because if it doesn't succeed, it becomes a grudge purchase. And if it does a grudge purchase, it's a lack of investment, and that affects us. So there's a self-interest, but it's not for free. It's by growing the industry. And I would encourage you, if you don't mind, just reaching out to any of us to come and ask how we can assist you in your organization lead. And I'm going to end off with a quote by the famous economist of the 20th century, John Keane, who said, "The difficulty lies not so much in developing new ideas as in escaping from old ones." Thank you very much.
Thanks, Darren. I think we have a question from a member in the audience, which I think will be good for you to answer because it really does tie in with exactly what you've been talking about. It's from Tanya Nassif, and she wants to know, what do we mean by reflecting IP on the balance sheet?
Thanks, Tanya. Well, basically, if you, I'd love to have a slide at my graph. So basically, if you're developing goodwill in a brand, you're going out marketing and expending this goodwill, you can't at the end of the day go and put that there as an asset on your balance sheet. So in other words, all the goodwill that's reflected on your, let's say, year, 2, 3 years work does not reflect on your balance sheet at the end of the year when you do your financial reports. I'm not an accountant, but I've asked the question many, many times. What about this goodwill that exists there? Why is it not reflected? And that's what we mean by doesn't internally generated IP is not reflected on the balance sheet. Of course, if you sell that company or that as a going concern, then the selling price reflects the value that you've created. And in that case, it exists on on the balance sheet of the purchaser. And that's often a way of, of people dealing with that, create IP holding companies for that very purpose. I hope that's answered your question.
Thanks, Darren. I think we can wrap up if you're happy with that. I think Karima is our next presenter, and she's going to pick up some of the strands that you've put out there for us and expand a bit on how to create an IP policy in your company and why it's important for us to have an IP policy. Karima is a partner in our trademark litigation department here in Pretoria. So over to you, Karima.
Thanks very much, Jenny. Good morning, everyone. So I'm going to quickly discuss today in like a blitz 15-minute session about IP policies. So we're going to go through what is an IP policy, the purpose and benefits of having an IP policy, and the scope, what you can include in the IP policy and what kind of clauses are typical of an IP policy. So jumping right in, you can essentially describe an IP policy as a formally adopted framework which deals with your business's ownership, management, and use of your IP. It essentially sets out the rules and strategies that you as a business adopt and that you need to use to identify, to protect, to commercialize, and to manage your IP. The IP policy also creates awareness amongst employees regarding the business's IP, for instance, for marketing purposes or for any sort of public engagement or relations. But it also highlights the risks associated with the misuse of both the company or the business's IP, but also very importantly, the IP of third parties. And by having a policy in place and a strategy in place here, the risk of third party infringements are diminished quite significantly. And I think, Darren touched on this earlier with remote working, the rules of engagement are sort of a little bit different now. People are working from home, and with that, the risk of exposure or the risk of losing value in your IP is quite high now. We also have the rise of consultancy now more than ever before. And with that, the relationship between the parties is different. And so an IP policy can help you achieve a balance between the rights of all the stakeholders involved. Essentially, it provides guidance on how to make decisions on a company's IP policy. Sorry, that jumped. More importantly, I think it provides legal certainty. So it ensures your business's compliance with national laws, regulations, and even best practices of your industry. And if you are in the industry concerned, it can promote creativity on research, technological development, innovation, and in that way, it's very beneficial for both the business and its employees. Now, in terms of the scope of an IP policy, it would be applicable and binding on all employees, and it should speak to or be linked to an employment contract. And employment contract should have a clause dealing with the employee's creation and use of the business's IP. But the policy can also create guidelines with respect to third parties. I mentioned earlier, and Darren also mentioned the age of consultancy. If you have independent contractors, although you may not necessarily be able to bind them to an IP policy, and I'm not saying you can't, but it'll set out guidelines how you engage with these third parties to ensure that your business's IP is adequately protected. So ideally, as a business, depending on the size of the business and the size of the IP portfolio, you could have an IP committee designated and then an IP manager or an officer. And this could be a director of the business, one of the managers, someone in the marketing department. It could be someone in the legal department or even the company secretary. And the role of this person would be to ensure compliance with the IP policy and to provide training to the members or to the employees and potentially third-party contractors on the framework set out and the guidelines set out in the IP policy. This person will also be responsible for providing general advice regarding IP. So employees will have clarity on who to approach should an IP issue arise or should there be a third-party claim of infringement. So it'll set out proper guidelines and frameworks so nothing falls through the loops. And this person will also be responsible for liaising with IP attorneys, instructing them to register IP. So this person will be responsible for, together with the other departments, to recognize or to decide what IP is registrable, and then to liaise with IP attorneys to maintain and to renew the IP. This person can also be responsible for conducting an annual IP portfolio review to ensure that you're adequately protected. And this speaks to what Darren said earlier today about having or viewing IP as an asset of the business and giving it the appropriate value that it has. So going in further into the scope of an IP policy, what can you include in your IP policy? The most obvious is trademarks. The IP policy can give you guidelines for the registration of trademarks. On the one hand, what is the business's strategy when it comes to registering trademarks? Do we register everything? Do we register our core brands? Do we register fleeting marketing campaign names? Do we register slogans? There's no right or wrong answer, but a strategy should be developed around this to avoid cost waste and also, long-term protection issues. But I think more importantly, an IP policy is good to have to set out what you should consider before adopting a brand name. We often have the situation where the marketing leg and the legal leg of a business don't speak to each other. A brand is developed, an entire advertising campaign, lots of money goes into all of that, only to be told at some point that you can't use the brand, either third-party right exists or for whatever other reason the brand is not usable. All that money wasted. Whereas with an IP policy, there's strict guidelines for what you should do when you, as a marketing department or whoever develops new brands or strategies, to first discuss with the IP manager, who will then liaise with IP attorneys to conduct a clearance check and to ensure that the brand can be used and then potentially registered by the business. The IP policy will also set out guidelines for how to use the trademarks of the business, whether that's on social media or in marketing campaigns. And I know a lot of employees struggle with the use of the registered icon versus the trademark icon or the TM symbol, and the IP policy will provide clarity in that regard. Another important benefit of an IP policy insofar as trademarks are concerned is that it can provide guidelines on licensing. It set out step-by-step procedure for what to do when a third party approaches you for a licensing opportunity. It'll include things like quality control, tax advice, like a checklist of things that you need to, like a due diligence list before entering into a license agreement. And of course, once a license agreement is entered into, to keep record of that. And then finally, I mentioned it earlier, when it comes to infringements, the IP policy will set out guidelines on what to do when your IP is being infringed, or your trademarks are being infringed, or if your employees or your business happen to be under threat of a third-party claim of infringement. Then we have copyright. So an IP policy would be great to give clarity on what is registrable as or not registrable, and what would qualify as copyright, examples of work that are eligible for copyright protection, what constitutes an infringement, what are the exceptions for infringement. Can also set out guidelines for subsistence and ownership of copyright. Of course, I'm sure everyone here knows that the ownership of copyright depends on the nature of the work and the relationship between the parties. In the case of commissioned works, I think most importantly, it must set out guidelines for what to do in the case where you commission either an outside marketing agency or any independent contractor to create copyright works for your business. The IP policy should strictly set out what to do in that situation. I would suggest that it includes, a template deed of assignment that every contractor signs before commencement on any work occurs. And then also, it would be very nifty from a litigation perspective to get an author affidavit signed by the person who created the copyright work. So if you have to prove your copyright at some point in the future, you have this document that sets out how the copyright work was created, and this will save you a lot of money in the future. And then I think with remote working, it's important to have clarity on the creation and ownership of copyright. You have employees working from home. The default position is that any copyright created by an employee would be owned automatically by the employer. But because of remote working, the lines are a little bit blurred. Someone could argue that they're working after hours in the evening to create copyright in something and that it doesn't necessarily belong to the business. An IP policy will eliminate any gray areas and ensure that the business is protected in this regard. Then moving on to domain names, it'll be good to have, a strategy set out in your IP policy for registering your domain names, including identifying which trademarks you would register as a domain name, or which brand names you would register and which wouldn't qualify for domain name registration, and then also which extensions, which domain name extensions you as a business would like to invest in. And by extensions, I mean .africa, .com, .coza, .finance, .biz, .gov. And the IP policy will, of course, again, set out how the portfolio should be administered. It will deal with infringements and the renewal of said domain names. Then we go to defensive company name registration. The Companies Act allows for any name. It doesn't have to be a trademark. It can be any mark or name to be registered as a defensive company name, and this will avoid third parties to register the mark or the name as a company name. So in your IP policy, in the same way with domain names, you set up a strategy for which brand names or which marks or brands in the business to register as a defensive company name, and then guidelines for maintaining those defensive company name registrations. With patents and designs, many still don't know the difference between a patent and design, and the IP policy can provide clarity on the difference between the two. It can provide clarity on what is registrable and what isn't, and guidelines on how to deal with an invention, for instance. It's very sensitive. It must be confidential. So it'll set out guidelines for employees so that nothing, again, falls through the cracks and you don't have a situation where you have a great invention on your hands, but it's unfortunately not registrable for whatever reason. Then we've got confidential information. I think, again, with remote working, this is very important. The risk of confidential information being leaked intentionally and unintentionally has increased quite significantly under lockdown and with remote working. And, the IP policy could set out guidelines for how to deal with those scenarios, but also how to prevent those situations from arising. And just to, for those of us who don't know, confidential information includes any technical, market, financial information of a business, including the know-how that is proprietary, secret, and confidential, and that is not known to third parties. So it's quite broad, and it includes things that are, for instance, not covered by copyright. And so it's important for you to have a set of rules and a strategy. You must adopt a strategy to ensure that your confidential information is protected. And then we have social media. With the increased trends of brand owners communicating with consumers via social media, the risk of, IP being abused or misused is higher, and especially given the immediate nature of social media, there's no take-backsies. So it's important to have you should essentially have a separate social media policy, but a social media in the IP context would be great to have in an IP policy to set out guidelines for employees when interacting with consumers on social media and using the business's IP on social media. And then finally, advertising. If your business advertises a lot, which most businesses should be doing, whether that's on social media or other platforms, it'll be good to have a framework and guideline for advertising. And this can include provisions of the Advertising Regulatory Board's Code of Advertising Practices. Although this is not binding on non-members, it does set out good guidelines and best practices for advertising. So as a business, you can consider adapting or adopting some of those provisions, and to ensure that all employees are aware and know exactly what they can do in terms of advertising, how to push the envelope, and what is going too far. And that's it from me, Jenny. Thank you.
Thanks, Karima. I've just been thinking, in terms of IP policies that would be binding on employees, If the IP policy is going to be binding on employees only, what would the scenario be for copyright where something's been created by someone outside of your organization? How would you ensure that that would be covered or protected?
Yeah, so I think this is how an IP policy can avoid any, bad blood happening between you and your contractor, your service provider. So I think it's essential to have guidelines and steps in place for engagement with these external service providers. I would say that the first step would be to have them sign a deed of assignment for work still to be created, or that a clause is included in that agreement that you sign or the brief that you sign with the service provider to ensure that any copyright in any work created is owned by you. And then also, like I said earlier, it'll save you a lot of money later if you have good record keeping to ensure that they get a deed of assignment, author affidavit signed.
Great, thanks. Just in terms of confidential information, where you're dealing with third parties, how would that impact on a policy, for example?
Yeah, so I think that's become quite relevant now. Darren touched on it earlier again, and I did speak on this during my discussion. The risk of confidential information leaking is quite high now. People are taking laptops home. Laptops can be stolen. You've got third-party service providers that you're working with. Consultancy is becoming a huge part of how we, work now. A lot of younger people prefer consultancy over being employees. And in that case, the risk of your confidential information and your know-how and your trade secrets being leaked or being shared unknowingly even is high. So I think with an IP policy, you can set out a checklist, again, for interacting with your consultants, for your employees, like a set of best practices for employees when working from home. Obviously, this will speak to, your privacy policies and also your IT, to ensure that your systems can't be hacked. I mean, we are in an age of hacking as well, and the risk there is high. But insofar as consultants are concerned, I think it should be rule of thumb that they would sign a confidentiality and non-disclosure agreement. And then also, if you're pitching to an investor, if you're pitching a marketing campaign or an idea to a marketing agency, it's good for them to sign a non-disclosure agreement. We often find, these kind of ideas. I mean, the Vodacom case, the Please Call Me case is probably an example of that. But in the business scenario, it can be quite expensive, an expensive mistake for a business.
I think one thing that we realize is that these are all things that we know. It's kind of like the common sense rule, but whether or not you've actually put it into place and ensured that everybody knows about it in terms of a policy is another thing altogether. So thank you very much for highlighting those important issues for us. I'm just going to ask our next speaker to get ready. It's Nicolette Bigger, and she's a partner in our trademark prosecution department in our sunny Durban office. Nikki's going to be talking to us about non-conventional trademarks, which is a bit of a buzzword at the moment. A lot of people are talking about it and what can and can't be registered as trademarks. So Nikki, over to you.
Thanks so much, Jenny. Some hard acts to follow there. I'm hoping that we can make it a little bit more interesting. I'm trying to shake things up a bit. So we've done a video, a pre-recording, just to make sure that non-traditional trademarks are experienced in the way that they come across. So I will be here after the video for any Q&A. So take it away. Okay, let's talk about non-traditional trademarks. I've decided to wear something traditional so that we can talk about something that is non-traditional. And that is what is so cool about non-traditional trademarks. I like to stand out and like to talk about these things that stand out and that are different, because as you know, the trademarks that you know about are things like letters and numerals and words and logos and devices, just your standard, McDonald's or your Coca-Cola or your Apple Those are the standard words and letters and sometimes even signatures, which sometimes taken as different. But these are your standard conventional trademarks. And I want to talk about non-traditional, or sometimes they call them non-conventional, a little bit unusual. So I'm going to talk about those and give you examples of those that you might not necessarily be aware of. And we're also going to talk about why they're different and how they are registered. Okay, so the term is broadly inclusive when it comes to trademarks, as it encompasses marks which do not fall into the conventional set of marks. Okay, non-conventional trademarks may therefore be visible signs like colors or shapes, or moving images, holograms or positions, or non-visible signs, for example, sounds and scents and tastes and textures. So my favorite are sound marks. And let's kick off with something that is very recognizable. Go for it. Yes, that would be your 20th Century Fox. And it's easily recognizable. You sit in the movie house and the first thing you hear, and then you know it's a 20th Century Fox movie. Well, even though these days at home, you're listening to it and you're hearing it when you watch TV. So for these sound marks, graphical representation of these sounds is very important. Here is another one by MasterCard. And then there is maybe something a little bit more recognizable is the Intel Corporation mark, which you could probably easily hear on your computer, your laptop, or when gaming. These are the types of sound marks that you would hear. So there are many sound marks registered in countries all over the world. You have your famous Nokia ringtone, the MGN Roar of the Lion. But a lot of people didn't know that these were something that were registrable as trademarks. And that is why it is so interesting to talk about non-traditional trademarks, because as long as you can use it as a trademark, it can be registered as a trademark. So moving on to other types of trademarks, and another one which is very interesting are the smell marks. But here you will find often that they don't get it right with smell marks, because it's important that your non-traditional trademark qualifies as a trademark. So it not only must be distinctive, and it must be in relation to goods and services, it must indicate the origin of your brand, but also it sometimes falls into those exceptions where you don't want it to serve a specific purpose or a function. So where there was, you cannot, for example, register a perfume as a trademark, because that particular smell is there to serve a particular purpose. It's to smell good and to make people smell good when they use it. So you would not be able to get a trademark for a perfume as the smell itself. But the most famous one would probably be the smell of freshly cut grass for tennis balls. Now, remember, as I said, trademarks must relate to goods or services. So in this particular case, the smell of freshly cut grass in relation to tennis balls. So it didn't serve a particular purpose, because the purpose of the tennis ball is to actually play tennis with. And the smell was merely to make it recognizable as that particular brand. So that was very interesting. Another type of non-conventional trademark is a taste mark. And here too, they have difficulty in registering these because they usually serve a particular purpose. And one of the known examples is with a pharmaceutical company that wanted to register the taste of artificial strawberries for their pharmaceuticals. And that failed because it served a particular purpose of disguising an unpleasant taste. Wouldn't it be lovely if your medicine tasted like strawberries or chocolate for that matter, but you wouldn't be able to register that as a specific non-conventional taste mark because it has to, it must not serve a particular purpose. Right, and one of my favorites, the other non-conventional trademarks, you get trademarks like moving images or holograms, but gestures is something now that has become very popular, specifically amongst the sporting fraternity, where you see a lot of these athletes, of course, the Ronaldo celebration when he scores. Not my favorite because I'm a Liverpool fan. And there are also other examples like the Gareth Bale, famous for the heart. Then the probably most famous gesture is the Usain Bolt one. And he has managed to register the gesture, but only as a silhouette, where you have the silhouette of him like that in that particular gesture. And you have the words bolting or light of a bolt or his initials, but getting that actual gesture mark registered as a trademark has also become very difficult. Another kind of moving image is the Lamborghini Doors, and these are registered in the EU. The description of that particular one is the trademark refers to a typical and characteristic arrangement of the doors of a vehicle for opening the doors are turned upwardly, namely around a swiveling axis, which is essentially arranged horizontal and transverse to the driving direction. So you see how important it is. And that's why when I talk about how we actually register these marks, there are specific criteria where it's necessary to get your mark registrable. And these were developed in the very famous Siegmund case, and it's now known as the Siegmund criteria. And we use that here in South Africa as well. The registry has specifically said that your graphic representation of your mark must follow the 7 Siegmund criteria, which is namely, it has to be clear and precise, self-contained, it has to be easily accessible, intelligible, durable, and objective. I won't go into a whole lot of detail there because that's what we are here for as your trademark attorneys. We will be able to advise you exactly how your non-conventional trademark needs to be filed. It's important, though, that you know that these are options for you as a proprietor and also in other countries as an attorney where your registry might not necessarily be open to these new types of conventional or non-conventional trademarks, and you file a mark anyway, but you make sure you know that the exact standards that are necessary to obtain registration are followed, and so that you can help your client or you as a proprietor can know that your mark can be registered as a non-traditional or non-conventional trademark. So look, there are various other types, and it remains to be seen where this is going to go. There are other things like feel marks, so, you know, textures, the shape of a chocolate, the color marks that also have become famous. For example, the Heinz baked beans that has particular turquoise. There's also the BP service stations that have managed to get their green for their trademark, and the most famous is the color orange for telecommunication services for that company Orange. So there has been some debate about whether proprietors should actually have a monopoly in these types of marks, because some view that they should be free for all to use. But I maybe should leave you with that particular question about whether these particular marks should be monopolized by specific proprietors. But if you are that proprietor and you want to be different, non-conventional, non-traditional, go for it. Come to Adams & Adams and get your mark registered. Thank you.
Thanks, Nikki. I was just thinking about the poor practitioner that had to try and explain the rights for the door, the opening of the doors. I wasn't sure I actually even understood all of it. It sounded more like a design registration than a trademark registration. I just have a quick question for you. What do you mean when you say that if you can use it as a trademark, you can register it as a trademark? If you could just perhaps explain a little bit about that.
Okay, thanks. I basically wanted to dispel the myth or the misconception that people have surrounding these particular trademarks, because just because they don't look like what we consider as normal trademarks doesn't mean that they're not registrable as trademarks. So at the end of the day, as long as proprietors can couple their products or services with particular sounds or smells or tastes or gestures to give them that distinctive edge, then there's always the chance that the particular smell or taste can be registered as a trademark. So, even if you don't start out using it as a trademark with the idea of getting it registered, if there is a certain non-conventional trademark or a smell or a gesture or a moving image that becomes associated with your goods or services, so your customers or your clients or your users actually make the link and they associate your particular goods and services with that non-conventional distinctive smell or taste, then you can apply for registration and justify it to the registry. So don't think that just because it's not something that falls within the standard definition of what a trademark looks like, that it's not possible to obtain or secure rights in that particular mark. So use it. And you never know, it could eventually become something that is registrable as a trademark. But, essentially, they are marks that are registrable. And I think proprietors tend to think that it doesn't necessarily fall within the normal bracket of trademarks. So they don't necessarily think that they can gain rights in that. But I think that those who want to be distinctive and want to be different and want to try something new in relation to their goods and services, these are great options for them.
Thanks, Nikki. Thanks. That's certainly very interesting. And I'm sure, I think as technology develops and as we're able and exposed to more things, I think you'll probably find that people are more sensitive to understanding rights in non-conventional trademarks. So thank you very much for sharing your ideas with us, and hopefully you'll be flooded with a whole lot of non-conventional trademark applications.
I'm hoping that's the
You
case.
may have to teach us in-house exactly how to deal with them ourselves.
I just wanted to apologize for the images. Technology is not always cooperative. So just for the image of that video, but I'm hoping the sound and everything came through easily there. And please be free to send me some questions, even if it's via email or on the chat. I'm happy to answer any. Thank you.
Thanks, Nikki. Thanks a lot. We're going to wrap up today's session with a run through some of the more important decisions that have come out of our courts in the last couple of months. Despite the fact that we've all been working remotely, the courts are still functioning, albeit on a remote level. You'll remember last year we had a slot where one of our advocate colleagues spoke about exactly what it's like to try and run a matter remotely. I'm going to hand over to Danielle, who's going to be our next presenter. Danielle van Deventer is an associate in our Johannesburg office, and she's a litigation guru inter alia, amongst other things. So over to you, Danielle. Share these exciting cases with us. Thank you.
Thanks, Jenny. Hello, everybody. I'm Danielle, coming from you very much alive from our Adams and Adams Santon office. One might think, as Jenny said, that the COVID-19 pandemic has led to a complete stall in matters heard by the courts, but this has certainly not been the case. During the last several months, a number of notable intellectual property and trademark-related judgments have been heard and handed down electronically by the South African courts. Today, to wrap up, we will be focusing on examples of recent trademark opposition, infringement, passing off, and unlawful competition matters. These cases include disputes relating to branded goods and services, ranging from luxury watches, the provision of soul food, men's shower gel, and even vodka misrepresented as whiskey. If you'll allow me a couple of seconds to just quickly start the PowerPoint presentation. Okay, hopefully everybody can see. So let's jump right in. We will be starting with the trademark opposition matter of Swatch AG versus Apple Inc., handed down by the Supreme Court of Appeal in January this year. The Swatch versus Apple case shows what would typically happen in a trademark opposition matter, where an interested party has the right to object to the registration of a trademark application by another on various grounds. In the present case, the respondent, Apple, applied to register its iWatch trademark for electronic timekeeping devices and watches, as the name suggests. Swatch opposed Apple's applications by contending that the iWatch and Swatch marks, as shown, were confusingly similar, and therefore that the iWatch mark was likely to deceive or cause confusion among South African watch consumers. Therefore, that the iWatch mark should not be allowed to be registered. This opposition was dismissed by the High Court with costs and subsequently appealed to the Supreme Court of Appeal, or SCA. The SCA was asked to finally determine whether the two marks Swatch and iWatch were deceptively or confusingly similar. It found that despite the use of the common element watch, the marks were visually, phonetically, and conceptually different. The SCA also concurred with Apple's contention that any likelihood of confusion was considerably diminished by the fact that a consumer who encounters a new product with the letter I would recognize that the product and trademark form part of the Apple I prefix family, for example, iPhone, iPad, iPod, etc. Accordingly, the court found that a visual, oral, and conceptual comparison of the marks did not yield similarities of sufficient significance to make the marks confusingly or deceptively similar. Furthermore, that consumers of the watches at issue were likely to be more discerning and more concerned with the precise brand of watch they require, with which I personally agree. Therefore, it was found that there was no likelihood of confusion or deception between the marks, and for these reasons, the appeal failed. This case is interesting because it illustrates the basic principles of comparing trademarks, bearing in mind how the trademarks would be perceived by the average consumer. The principles applied in trademark opposition matters like this one are likewise also applied in trademark infringement matters to determine a likelihood of confusion or deception. This will be seen from the following two cases brought by Golden Fried Chicken, who for those, like myself, did not know, trades as the well-known fast food outlet Chicken Licken. These are in short, Golden Fried Chicken versus Oh My Soul Cafe and Golden Fried Chicken versus Soul Souvlaki. Both these cases focus on trademark infringement in terms of Section 34 of the Trademarks Act. The applicant in both cases, Golden Fried Chicken or Golden, sought to interdict two different restaurants for the use of certain trademarks containing the word soul on the basis of prior registered soul and soul food trademarks for restaurant services. In the matter against Oh My Soul Cafe, with neither the facts nor the general principles in dispute between the parties, the only issue for determination by the court was whether Oh My Soul Cafe's use of its soul trademarks was likely to deceive or cause confusion. Golden is the owner of various registered soul and soul food trademarks. It sought an interdict against Oh My Soul Cafe for its use of trademarks Oh My Soul Cafe, Soul Food, and Soul Food Sunday. Golden articulated the history and composition of its soul brand, comprising an African-American concept of soul food or music, and pride in Afrocentric heritage and a rising above racial prejudice. On comparison, Oh My Soul Cafe characterized its business as a lifestyle restaurant, supplying goods and services to vegans, describing veganism as a philosophy premised on the belief that animals have souls. The court found that the word soul had different meanings for both litigants, with its use in either context being diametrically opposite to one another. Golden and its various trademarks being well known in the Republic for chicken products, which products are in reality the very antithesis of veganism. It was held that vegans are discerning consumers most unlikely to confuse or associate Oh My Soul with Golden's conception of soul or soul food for fried chicken. Furthermore, and quite thrillingly, the court finally held that if Golden's Soul brand had the remarkable capacity to communicate to its consumers African American cool and a pride in Afrocentric heritage, then, in the spirit of Ubuntu, Golden should, in national interest, encourage rather than restrain the use of the word soul to mend social fractures by allowing small businesses to survive attacks by large corporates like itself. The application was accordingly dismissed with costs. Likewise, in the second case, the restaurant Soul Souvlaki was the respondent to a further interdict sought by Golden. Materially, souvlaki was in the business of selling souvlaki, a type of Greek street food, under the name Soul Souvlaki since 2012. The central issue again revolved around Golden's registered trademarks of soul and soul food versus souvlaki use of soul in its Soul Souvlaki name. In counter, souvlaki launched a counter application that sought the removal of Golden's registered soul and soul food marks from the trademark register. The court held that the fact that both entities provide food or restaurant services does not in itself imply that there will be confusion or deceptive similarity between the two. Golden described itself as stated as associated with African American culture, while souvlaki clearly denotes a Greek influence. Accordingly, the court found that there was no trademark infringement. As to souvlaki's counter application for the removal of the marks, the court found that if Golden attempted to register these trademarks in the present day, it likely would have been unsuccessful having regard to the meaning associated with soul and soul food. Nevertheless, it was held that Golden's mark had acquired, within a limited market, the ability to distinguish. The court thus dismissed both Golden's application as well as the counter application. The Swatch and Golden Fried Chicken cases show that a registered trademark does not always provide blanket-like protection to monopolize a word or concept. That said, our law does provide for aggrieved parties to obtain relief against third-party copying of their brands and get up based on unlawful competition, which can take many forms, one of which is passing off. The appeal case of Coney Multinational Brands versus Beiersdorf AG, handed down by the Supreme Court of Appeal this year, is case in point. The SCA dismissed an appeal by Coney Multinational Brands against the High Court's decision, ruling that its Coney Men shower gel products were confusingly similar to Beiersdorf's well-known Nivea Men shower gel. The products concerned and their devices are depicted on screen. In 2019, the High Court ruled in favor of Beiersdorf, interdicting Coney from competing unlawfully with Nivea by passing off its Coney's Men shower gel products as those of Nivea. Coney appealed this judgment. However, the majority of the appeal court found that the get-up of the Coney Men active shower gel was too similar to that of Beiersdorf's Nivea Men shower gel and therefore maintained the decision. That said, the decision was not unanimous. One of the appeal judges did not agree with this view and believed that only a careless consumer would end up purchasing Coney shower gel rather than Nivea. This in going with the principle that a certain measure of copying is permissible, provided that a competitor takes the necessary steps to differentiate its goods from those of another. Notwithstanding this, Coney was ordered to remove the disputed products from all stores, including signage, printed material, websites, and social media. Lastly, as was shown in the Supreme Court of Appeal case, judgment of Milestone Beverage versus the Scotch Whisky Association, unlawful competition extends well beyond only passing off. The Scotch Whisky Association, or SWA, was established as far back as 1912 with the purpose of protecting and promoting the interests of the Scotch whisky trade. The SWA brought an application for an interdict against Milestone Beverage and its owners for competing unlawfully by selling liquor that looked like and was promoted as whiskey, but was in fact a vodka-based spirit. The claim was brought based on unlawful competition on the basis that Milestone was misleading the public by attributing connotations of whiskey, and specifically Scotch whiskey, to the product, and was trading in contravention of not only the Consumer Protection Act, but also the Liquor Products Act. Before the SWA objected to Milestone's use of misleading terms like whiskey, Scotch, or Scotland, and insignia evocative of Scotland, these products were actually sold as whiskey and thereafter only sold as whiskey-flavored drinks. As shown from the images on screen, Milestone used get-ups involving tartan patterns. They also used brand names like Royal Douglas and King Arthur that were apparently intended to further enhance the idea of Scottish heritage. The SWA filed legal proceedings claiming that Milestone was unlawfully competing by falsely projecting a Scottish origin to its products, misrepresenting them as Scotch whisky, alternatively whiskey. Milestone's conduct also contravened Section 12 of the Liquor Products Act, which prohibits false or misleading descriptions for liquor products. The court found that Milestone was guilty of unlawful competition and issued broad prohibitions interdicting Milestone from misrepresenting its vodka-based spirits as whiskey or whiskey-flavored, using get-ups reminiscent of whiskey or Scotland, or misleading terms like whiskey, Scotch, Scotland, or insignia suggestive of Scotland. This is a fairly difficult judgment to follow, but it sets the scene for just how unlawful competition can be utilized in the absence of registered trademark rights. In conclusion, here are 5 takeaway points from these 5 cases to keep in mind. As far as possible, choose a distinctive trademark which does not consist exclusively of purely descriptive commonplace matter or a term which may constitute cultural appropriation. First, conduct trademark clearance searches before settling on a name to avoid costly objections later on. Invest and conduct diligent market research for your industry before deciding on product packaging and get-ups. Remember that to remain competitive, a certain measure of copying is permissible, provided adequate steps are taken to differentiate your goods or services from those of another. And finally, be careful not to use fake or misleading statements and advertising in relation to your products or services. And then lastly, also keep in mind what the advertising guru Les Burnett once said. The secret of all effective advertising is not the creation of new and tricky words and pictures, but one of putting familiar words and pictures into new relationships. And here lies the rub. Strive not to antagonize your competitors by using words, phrases, images, or ideas which they have already appropriated. Thank you.
Thanks, Danielle. I think many of us were aware of these cases that were ongoing at the time and were anxiously awaiting the outcome of some of them. I've just been thinking, so do you think that the owner of the Soul Food trademark, I mean, would he have any recourse? I mean, are his rights basically of no value, or would he be able to exercise his rights against other restaurant owners?
Well, definitely in the fried chicken space, Jenny. He still has, as the court stated, he had a limited reputation for those specific products. Say, if, for instance, KFC had to start the Soul Food or Soul Food Sunday Day, he would be able to take action against them still. It'll just have to be closer, not vegans or Greek food.
Okay, all right. Just an interesting thought. I mean, so courts have been functioning remotely. How are the proceedings being run, and how are judgments actually being handed down? Because in the past, we'd all get the anxious phone call and get a counsel and go off to court and sit in court and hear the judgments. So how are those judgments being handed down now?
So that's very exciting developments. For those who didn't know, there's actually an electronic platform that I think everybody is currently using, High Court, Supreme Court of Appeals Court case lines, which you can actually upload all your documents onto that case lines platform, and then judgments and cases are being heard electronically, like on MS Teams or Zoom. So yeah, that's very interesting, and hopefully that will help alleviate some of the burden of backlog.
And are the judgments then placed, are you notified when the judgment gets placed on case lines, or
Yes.
so you just get a
Same
notification?
system. You just don't go to court, and
Yeah.
they actually give you a date, and then you just pitch on the MS Teams meeting.
Yeah, I did think the other day that there's something that we missed that almost in a way, you know, especially getting to the Supreme Court of Appeal in Bloemfontein. It's always a highlight in every South African attorney's career to be able to go down to Bloemfontein. Well, thanks, Danielle, and thanks for sharing those insights with us. So believe it or not, we've come to the end of our morning's presentations. There are just a couple of housekeeping issues that I want to raise with you. We are going to be doing a survey, so can you please complete the survey? Today's proceedings have also been recorded, like the courts, and the court recording will be available on our website. So please, if you want to just catch up and go back and listen again, please do. Right, there we go. In the chat box is the survey. Please, will you complete the survey? Because only if you complete the survey and tell us what you think are we able to improve on how we do this every year. Tomorrow is another exciting lineup, so please, if you haven't registered, do so. Demi Pretorius is going to be the MC tomorrow, and she's going to take you through tomorrow morning's program. As I said, it starts with a presentation or discussion with Advocate Gilbert Marcus, the Senior Counsel from the Bar, who will be speaking about mandatory vaccinations in the workplace. Thank you to everybody who joined today. I'm sorry we're exactly 1 minute over time. I didn't think we were going to do it, but we managed. It was great to see you all, and look forward to seeing you all again next year. Thanks, everyone. Bye-bye.